Hello, welcome to today's Charities Lean Forward webinar, Litigation Risk Management. This webinar is jointly organized by the Charity Council and Law Society Pro Bono Services. My name is Serene and I'm your host. Before we start, some housekeeping matters. Please feel free to ask any questions at any time during the webinar using the Q&A function. We will do our best to address your questions during or at the end of the talk. The handouts for today's talk will be emailed to you later this week. However, do note that today's discussion and materials are not intended to substitute any form of professional legal advice. If you require specific legal advice, please consult a lawyer. For today's program, we will first have an opening address by the Charity Council Chairman, Dr. Gerard Ee. This will be followed by Ms. Aurill Kam, who will briefly speak on key areas of litigation risk. We will then walk through 2 case scenarios that charities may encounter, and finally, we will end off with a Q&A session. I am privileged to introduce to you Dr. Ee. Dr. Ee is the chairman of the Charity Council at the Agency for Integrated Care. He was former president of the National Council of Social Service and the National Kidney Foundation. Dr. Ee is a fellow chartered accountant of Singapore and serves as an advisor to the Institute of Singapore Chartered Accountants. On an international front, Dr. Ee serves as the vice president of the ASEAN Federation of Accountants. I will now hand over the time to Dr. Ee to give the opening address.
A very good afternoon to each and every one of you. I'm very happy to join you today at this Charity Lean Forward webinar. Firstly, I would like to thank the Law Society Pro Bono Services for co-organizing this very timely webinar for us to discuss about potential litigation risks that our charities face in their line of work. A very big thank you to our distinguished speakers and panelists, Aurill, Peggy, and Angeline, who will be sharing with you great advice. When we hear about risk management, many see it as a chore that needs to be done but adds little value to the charitable work that they are doing. This is untrue. Risk management is critical as it protects your charity's reputation, resources, and people. For example, when an external data breach or inadvertent internal error that caused an unauthorized disclosure of your donor's personal data, there could be serious reputational damages, and you need to spend more money to rectify the problems urgently. Safety risks include miscommunications with volunteers, which may lead to incidents where volunteers accidentally get injured during an event organized by the charity, or volunteers get bitten by animals due to the lack of training in handling the animals. Potential volunteers and donors may also be deterred from helping this charity, hence leading to a decrease in support, leaving the charity's beneficiaries more vulnerable. The potential for litigation in such cases is real too. Even though it is impossible to eliminate all risks, all charities, regardless of size or the area they serve in, should always seek to implement proper structure to minimize the risks and to demonstrate to stakeholders and donors that their charity is using their resources ethically and efficiently. This will help your charity to achieve more for your beneficiaries and increase your charity's governance standards. The board should ensure that there is process to identify, regularly monitor, and review the charity's key risks. Board members can help to identify the risks and find ways to mitigate them. For instance, this could be done by categorizing and transferring certain risks to third parties, such as the insurance companies. The simplest form could be an accident coverage for employees, volunteers, and beneficiaries. The board should also be clear which activities carry certain risks and if it is necessary to undertake them. There should be sufficient mitigation measures and controls put in place. For instance, a charity may explore using an overseas company digital tool to conduct fundraising activities locally. The potential risks may include cyber incidents, data breach, or fraud. Without a plan to mitigate such risks, the board should not proceed to conduct the fundraising activity via the proposed platform unless they have properly assessed and devised solutions to mitigate the risk. Board members can also help to minimize their charity's risk exposure by serving for the right reason. And this includes putting their charity's interests above their own personal or their peers' interests. The board chairman should hold all board members accountable for their commitments and duties, such as attending the required meetings regularly and understanding the policies well so that they can lead their committees with integrity. Although it is the core responsibility of the board to manage the risk, they also need strong support from the management to fulfill their roles effectively. Management should provide regular communications to the board on all matters, including developments of the charity's programs, updates in policies, or changes in staff movement. An under-informed board will not be able to provide the charity with the needed advice during a crisis or take the right action to rectify any adversities. The management can also help the board to minimize risk by having a proper due diligence process. For example, before presenting a program to the board for their approval, the management of a senior activity center will carry out reasonable checks to ensure that quotations are sought, vendors who will be providing artworks, for example, for the seniors are legitimate and have the capacity to deliver the services. Whether it is a contract with a vendor, establishing a corporate partnership, or collaborating with volunteers, conducting due diligence checks prior will help your charity to make the most informed decision possible and minimize the risk before going into any kind of collaboration. There is a wealth of resources on risk management and governance on the charities portal, as well as grants that charities are strongly encouraged to tap on to help them with risk management. For example, the Enterprise Risk Management Framework can be found on the charity portal. It shares practical insights and recommended approaches for charities to manage their risk. Charities should refer to the best practices to start building an efficient and sustainable ERM or Enterprise Risk Management Program. The second example is the VWO's Charities Capability Fund or VCF Consultancy Grant. This grant subsidizes the engagement of external consultants to review your charity's internal processes and policies to improve key governance areas. For the past years, we have supported multiple projects that covered areas such as risk management, manuals development, internal audit, and many more. The application period for the VCF consultancy grant is now open until October. Please apply and use this grant. Lastly, having a good risk management practice in place not only benefits the charity itself, but it also increases public confidence of the charity sector. We want to recognize such charities as their inspirations to all of us. As part of the Charity Transparency and Governance Award, we have been awarding special commendation awards to some charities for their exemplary standards in operational processes. HCA Hospice Care, who is on our panel today, has also received the Special Commendation Award for Risk Management in 2018. They placed great efforts to implement a sound risk management framework and transited from being reactive to proactive, enabling their stakeholders to view risk through the much broader lens of the entire organization. By this time, you have heard that the Charity Transparency and Governance Award is back, and we urge you to submit your application very soon as it closes on the 31st of October. It is very simple to fill out the form online, and if you do need help, we have partnered with SMU student volunteers who have also been contacting you to provide consultation clinics to assist you with the form submission. The consultation clinics are in high demand, so we recommend you to quickly book a slot with these students and submit applications early. Receiving this award demonstrates that your charity's passion, drive, and commitment to pursuing excellence in governance and providing the best care for your beneficiaries. We look forward to having as many charities achieving this award as we ever had. Together, we can raise the overall charities sector standards of governance and help to boost the confidence of our stakeholders. Let us make a positive difference in the community as we stand proudly as a strong charity sector in Singapore. As the saying goes, do something every day that you don't want to do. This is the golden rule for acquiring the habit of doing your duty without pain. Be conscious of your activities and processes and try to take a small step every day or week to assess them for potential risks. Over time, I hope that the task of managing risks will no longer be a chore, but a natural activity which adds to the foundational work of the charity. The stronger the core foundation of charity, the greater the gains are for the beneficiaries and for charitable purposes. On behalf of the Charity Council, I'd like to thank all of you for joining us this afternoon, and I really look forward to an inspiring conversation ahead. Thank you.
Thank you, Dr. Ee. For our next segment, Ms. Aurill Kam will provide an overview on forms of legal liability and litigation risk management approaches. By way of introduction, Ms. Aurill Kam is a director with Legal Clinic LLC. She's a senior litigator with over 29 years of experience spanning both private practice and public service. She has advised on numerous cases throughout her career, including complex civil and commercial claims, regulatory enforcement, and public law matters. Her public service experience includes heading 2 different departments at the Monetary Authority of Singapore and being Deputy Chief Counsel at the Attorney General's Chambers Civil Division. Aurill, over to you.
Thanks, Serene, for the introduction. A real pleasure to be here this afternoon. I have actually prepared a deck of slides for this afternoon's presentation, but in the interest of time and so that we have enough time for the Q&A as well as a case study segment later on, what I want to do is just focus on some of the more salient slides rather than go through each one. And through this, I hope to provide a quick overview of some key aspects of litigation risk and what we can do to try to better manage such risks. Now, let me start with forms of liability. Can we have the next slide, please? Here you see the 4 main clusters or groups of forms of liability. I'll leave you to just take a quick glance at the slide. And I want to spend some time now talking about each of these forms of liability. Next slide, please. Criminal liability. Now, criminal liability arises when there is a breach of a criminal statute. So an example of a criminal statute is the Penal Code, for instance. And when you hear of things like criminal breach of trust, theft, these are offenses under the Penal Code. And the types of sanctions or consequences that arises as a result of criminal breaches is that you get fines or imprisonment. Next slide. Now, a very close parallel to criminal liability is what is known as regulatory liability. Now, not all breaches of statutes would give rise to criminal sanctions. Now, for instance, depending on the severity of the breach, under the Charities Act, some breaches will result in criminal sanctions and some to what is known as regulatory consequences. Regulatory consequences are by and large less severe, less draconian than criminal ones. Even if there is a fine, it would be a smaller one. You won't be looking at imprisonment, but you could be looking at some form of sanctions such as revocation of a licensing status or the removal of a right to do something or a suspension of sorts. So that is what we call regulatory liability. Next slide. What is a statutory tort? Now, a statutory tort is a right of action that is conferred by a statute on the victim to bring a claim under civil law against the wrongdoer. So, for instance, under the PDPA, if there has been a breach, a data breach, the PDPC may issue directions on the wrongdoer. And that would be what we call a regulatory action. The PDPC can say to the organization, you are to be prevented from collecting data, or you are to do a review. Now, all these are what we call regulatory sanctions. But over and above that, the PDPA provides that a person who has suffered loss or damage as a result of an organization's breach of the PDPA, such a victim can actually bring a private action against the wrongdoer for a claim in damages or monetary compensation. So this right of a private claim is known as a statutory tort. Next slide, please. Now, so statutory tort, as I've mentioned earlier, it arises from a statute, but you have other types of civil liability that does not find its source or its premise or basis on statute law, but rather what we refer to as the common law. So there are two forms of civil liability that we will be looking at. There is first what we call contractual liability. So it's a liability that arises in private law from a contract. And there is tortious liability, which is liability that arises out of someone's actions or omissions in dealings with others. Next slide. The types of remedies that one would get in civil liability won't be in the nature of fine, won't be in the nature of someone issuing a direction and saying do this or do that, but it would by and large be in the form of monetary compensation, which in legal parlance is referred to as damages. Sometimes civil liability can also give the aggrieved party the right to ask the court for an injunction, or that's called a court order, that will compel someone to do something or to restrain someone from doing something. Can I move to the next slide, please? So there you have it, in a broad framework, the main forms of legal liability. Now we want to look at risk management, legal risk management. Now, when we talk about legal risk management in this webinar, we are focusing mainly on that last category of liability that we just talked about earlier, which is civil liability. Now, this is not to say that other forms of legal liability, such as criminal liability or statutory liability, are not important, or that the legal risk arising from them cannot be managed. Just purely because of time constraint, and also because civil liability is by and large the more common form of liability that is faced, we focus on the management of civil liability risk in this webinar today. The other thing I want to say is that when we again think of risk management, we must be mindful that we're really talking here about the reduction or the mitigation of legal risks. We're not talking about the elimination of legal risks. That, as we all know, can never be done completely and fully. And thankfully, the lawyers among us will say, thankfully, it cannot be done. It cannot be eliminated. Otherwise, we would be out of work. Now, let's move to legal risk management then. Next slide. Okay, I want to talk about management of legal risk arising from contract, right? Now, when you contract with suppliers or with third parties, do you consider whether it is necessary to negotiate contractual clauses that may appear unreasonable? I know that many of the people that you will contract with will tell you that these are standard form contracts, but that doesn't mean we shouldn't review them and critically ask whether some of the terms are unreasonable or unfair, or whether we should negotiate them. I'm also aware that because of costs, some might say, well, let's just look at online templates. There are so many of them these days. Let's just compare against an online template. I'm not saying that that shouldn't be done. I think for small value contracts, and if you assess the risk to be very low, yes, by all means, use an online template, a DIY online template to do a comparison. But where the value of the contract is large, where the risk could be significant, then one should think about whether there's a necessity to bring on board lawyers to seek legal advice, right? And some of the provisions that, as we look at these contracts, we should be sort of a bit more watchful for would be things like exclusion or limitation clauses, where the other side is saying, under these conditions, I will not be liable to you. Right? A lot of them are reasonable, but sometimes you will find almost bordering on oppressive type of limitation or exclusion clauses. Also limitation periods. The normal contractual limitation period is 6 years, and that for personal injuries is 3 years. But contractually, it is possible that some people will vary that. So be mindful of what is in all these contracts. There are sometimes also liquidated damages clauses, which will say, if I breach the contract, I'm only liable to you for X dollars. Again, that's something that you should look at. Is it reasonable in the context of the contract that you're entering into and how much you are spending on that contract? Can I have the next slide, please? Now I want to talk about managing risk, legal risk vis-a-vis your volunteers. To your volunteers, yes, show a lot of love, show a lot of appreciation, but also consider, are there things that we can do to better protect them? Should we, for instance, have operative terms and conditions so that volunteers are clear about how they should conduct themselves vis-a-vis other volunteers, vis-a-vis the people they serve? Are they clear that they have no authority to represent the organization and to bind the organization? Now that's important because your volunteers can say things that can get your organization in serious trouble. Are the volunteers clear that they are responsible for themselves and their property when they are in your premises, when they're carrying out activities that are run by your organization? So it is worth sparing some thought in these areas. Now, what about protecting your volunteers? What about, anti-harassment policies? Do you have any of those? What about whistleblowing policies? Do you have any of those that will protect the governance of your organization, the reputation of your organization? So these are, again, a cluster of things that one can look at when you are thinking about legal risk management that can come from dealings with volunteers. Next, the people you serve. Next slide, please. Now, the people you serve, do you also take steps to protect them and mitigate or minimize liability for items that are lost in your premises, injury that is sustained in your premises during activities? Do you, for instance, in slightly higher risk activities, send out advance sort of notices or warnings to people who may participate in them? Like if you're going to run an obstacle course, do you at least say, please ensure that you are fit, that you have no issues with mobility, etc.? Do you take these steps, right? So can I have the next slide, please? So one of the things I think a lot of people think about is putting in appropriate signages, telling people about slippery floors, leaving cautions about checking for your belongings, locking the doors, etc. Now, these are small steps, but they're worth taking. Now, of course, when it comes to disclaimers or cautions and signs, we have to take a balanced approach. So can I have the next slide, please? What we don't want to do is to end up in a situation where management is saying, I'm not responsible for anything. Now, that's a very bad signal to send. But what we're saying is exercise, sound judgment in what you want to alert people to and give cautions and warnings about. Now, let me now move to the next area on dispute resolution. Can I have, now I'm going to skip this slide because I'm sure this is something we'll talk about later on when we do the case study. But I want to now just talk about different forms of dispute resolution very quickly. First, there is this form of resolution known as litigation. Now, litigation is essentially a court process where a judge makes findings of facts. He will resolve the dispute between two parties by deciding who is in the right and who is in the wrong. So in litigation, there will always be a winner and a loser, and the outcome is a court judgment or a court order. So with the exception of family proceedings or proceedings involving minors, all court proceedings are not confidential, and there is open access to the information in court proceedings. A variation of that is arbitration. Arbitration is like litigation in that it is a dispute resolution process for which there is an adjudication of rights. And the person who decides this is not a judge, but he's like a judge. He's an arbitrator, or there will be a tribunal, a panel of arbitrators. And they do the same thing. The tribunal or the arbitrator will adjudicate between right and wrong. The difference between litigation and arbitration is that arbitration, by and large, is confidential in nature. Also, the adjudicator in arbitration need not be a lawyer, can be a technical specialist. So certain types of contracts, such as construction contracts, engineering contracts, would be suitable ones where if there is a dispute, you want it to go before arbitration. Number one, because it is confidential. Number two, because you can have technical specialists such as engineers, sitting as the adjudicator. But arbitration is invariably more expensive than litigation. So it is, whether to go for arbitration or litigation is something that you have to think strategically about. Arbitration also is a process which you need parties to consent to use. So parties either consent to arbitration as a form of this dispute resolution at the time that they enter into the contract, or if after the dispute has arisen, they agree, all right, we're going to put this by arbitration. So arbitration is a little bit more convoluted. Right? Now, finally, there's mediation. And I think this is something I want to spend a bit of time on. Now, mediation is not like litigation nor arbitration. There is no adjudication of rights. What happens in a mediation is that parties come together. They will be facilitated in their discussion by a mediator. And the object of the mediation process is to help parties talk through the issues, arrive at a consensus and a solution on how they want to resolve the dispute. So there is no determination of the merits. There is no right or wrong or clear outright winner or loser. If at the end of the process, parties agree on a mode in which they can settle their dispute, I pay you X or you give me an apology and we say this is the end of the matter. If there is some a compromise reached, then the agreement goes into a settlement agreement. If parties cannot agree, then they walk away. Their legal proceedings, if they have started one, is not affected. They can carry on with it. If they haven't started legal proceedings and they want to, they are not prevented from doing so. So mediation is a very useful process if you get into a dispute situation and you don't really want to spend time or money litigating it, or if you find that, well, there are certain reputational risks or issues that you need to manage, then you want to look at mediation as the first port of call before things even heat up and get to the litigation or arbitration phase. That's all I really have to say in terms of a broad overview on legal liability. So over to you now, Serene.
Thank you all. Let's walk through 2 case scenarios to see how litigation risks may play out in real life. So to discuss our case scenarios, I would like to invite Ms. Peggy Yee and Ms. Angeline Wee to our panel. Ms. Peggy Yee is a lawyer with PY Legal LLC, having been in private practice for more than 30 years. She's a member of the Charity Council and is passionate about providing assistance to the disadvantaged through the many social causes she is involved in. She is the Vice President of the Disabled People's Association and also sits on the boards of various other charities and social organizations. Ms. Angeline Wee is the CEO of HCA Hospice Care, Singapore's largest home hospice care provider and a registered IPC charity. She crossed over to the charity sector in 2015 after spending 33 years in the IT industry working at various MNCs. She believes that for a charitable organization to thrive, its people are its biggest asset and governance structures help instill public confidence. But at its very core, it is the deep compassion for humanity that fuels the passion of the many dedicated individuals working alongside her. Thank you, Angeline, Aurill, and Peggy for joining us today. Our first case scenario deals with a charity activity. Apple Charity organizes an outing for its volunteers and beneficiaries to Bukit Timah Hill. A beneficiary falls down on the path and injures himself. Or what are some things that charity should be mindful of when faced with a potential legal claim?
I think engagement is very important. So I think the first thing that one has to do is to engage the other side in a timely and appropriate manner, especially in the immediate aftermath of the event. So in this current scenario, I would imagine that someone has to reach out to the beneficiary who has fallen and the next of kin, express sympathy and concern, pay a visit, make a call the next day. It really helps to de-escalate the situation. And what you don't want is to not manage the process and to let it wield a life of its own, as it were. The second thing I think you have to do is that as soon as practicable, you must collate all the relevant information pertaining to the event, because after some time or after lapse of time, people's memories fade and things are forgotten. So you do want to get witnesses' written account. You would want whoever was there to write down an account. You would want the person who was running the activity to write down a report of sort, an incident report. You would want photographs of the site or of the injury. You would want to gather all the forms or brochures that you had used for the event, put them together. And all that would be with a view to bringing them to a lawyer, seek legal advice early, right? What should we do? How do we manage this situation? A lot of people think that going to see lawyers means you must necessarily sue, but that's never the case. Actually, you are going to see the lawyer to say, well, how do I manage this? And in most cases, most of my clients would be saying to me, how do I manage it so that it doesn't get to the courts, right? The next thing I would say is one must be very careful about making admissions, all right? I know there's a fine line to be drawn between showing sympathy and concern, but openly admitting, especially in writing, oh, we were wrong, we should have done this, we should have done that, is always a little dangerous. It is sometimes done. It can be done, but I would say do it on a considered basis, only with legal advice. And finally, if you have an insurance policy, one of the things you must do is you must check your terms. You must, I think most of the insurance policies will say you are to notify the insurers immediately. And a lot of them would actually say you don't take matters into your own hands. You consult with the insurers. They might sometimes say we take over, right? So these are some of the steps you need to walk through.
Thanks, all. No, I think those are very good points that you mentioned. Basically, don't ignore the problem. It's not going away. In fact, it may escalate if you choose to ignore it. As well as you said, gather information, because memories do fade after a while. Even if someone, after they falls down, maybe it takes them weeks to come back to you. You did raise the point where you said, be considered, or do think about it before you, as you said, you say, I'm very sorry, or I did something wrong. Maybe you could explain a bit more about that. Like, what's the significance of saying I'm sorry or I'm wrong?
I think, I mean, we put ourselves on the other person's, in the other person's shoes, and something has happened to you. I think it makes a lot of difference when the person who's supposed to have taken care of you says, I'm sorry for the injury you suffered, right? It's a question of what you're apologizing for. You must, I think, show empathy and concern for the pain or the suffering that they are going through. But you then, I think, so as to not compromise the position of your organization, must not be too quick to then say, yes, we should have done this, we should have done that, we failed in this or that. So I think that is the fine balance, right? To admit liability or to admit fault too readily.
I see. So the concern is about, as you said, wording and being careful not to admit liability, especially if you may not necessarily be responsible in the heat of the moment. So Peggy, going beyond the law, do you have any practical tips to add?
Yes, thank you, Serene. Actually, whenever something happens, like in this case, the beneficiary falling down and injuring himself, whenever something happens, the first thing that tends to be said is, if only we had done this, if only we had done that. So as they say, hindsight is always good. But if this hindsight, which we know is impossible, right? If hindsight can be viewed as foresight, so if you can anticipate it more, then perhaps that question that is typically asked, as in, if only we had done that, why didn't we see this? Then that might be better managed and better answered. So moving from foresight, I then want to agree with Aurill first when she said that risks will always be there. It can never be eliminated. You cannot get rid of risks. In whatever that you do, whether we do it as a charity or not, there is always a risk. But especially when we do things as a charity, the risks that are there are manifold. And Aurill has touched on a few aspects, quite a few aspects of those. They cannot be eliminated, but they can be managed. So if we look at it from the question, from the eyes as in, how do we as a charity manage those risks? That's a very broad question, because in order to do that, we first have to ask ourselves, what is a risk? We use the word risk. So this is one scenario, but we know this is only but one, because many things can happen in the course of things that are done in the course of a day, in the course of a transaction, in the course of a program. So how does the charity identify the risk? How then do they manage the risk? Does the responsibility, as Chairman has said, Chairman has pointed out that there are these levels, the board of the charity, the management of the charity, and then there's also staff. So at which level and to what extent does each of these levels take ownership and responsibility of identifying this risk? How do we even know what this risk is? So I would like to invite charities, if they are considering that, to bear in mind there is a code of governance which applies to all charities. This is found on the Charities portal. The Code of Governance sets out all the good practices and the principles of good management and good governance that charities should adhere to. Because it is a code, it sets out, it's not mandatory, although it is in alignment with various statutes, one of which Aurill has already brought you through, the Charities Act. Besides the Charities Act, there are also quite a few other charities-related regulations that are also in a website that charities can look at. So when you know that there are these regulations that are there, in order to make it simpler for charities, these are synthesized into the Code of Governance. And to make it even more practical for charities to find their way and navigate themselves, the best practices are broken down into disclosure areas in what is called the Charity Transparency Framework. It's called a framework because it's like a roadmap. It helps the charities to see very practically for themselves which are the areas that they can address their minds to. So I'll just give you some examples because it's all in the charities portal.
Yep.
There are 9 areas of disclosure. So if I apply that to this poor man falling and injuring himself, one of the areas of disclosure set out in the Charities Transparency Framework would be program management. And then another area is human resource and volunteer management. So if a charity, in whatever that it does, when it goes through, and this should not be event specific, this should be something that a charity approaches from the top as board, petering down the culture to management, and management then giving the appropriate and correct directives to staff to implement. So it's not something that's just, here's a copy of it, everyone keep it in your file, and then we forget about it. It's something that must be lived out for the charity. So if the charities look at these areas of disclosure, the 9 areas of disclosure, one of which also is board governance and executive management, because if you have a good board and you have good management, they will then be very much alive and be very concerned about what the possible pitfalls are and examine thoroughly what the possible, let's say, loopholes are, and what are the possible scenarios that can happen whenever there's an event. Or for example, as Aurill said, because of time, she has focused and she has focused on civil liability, very appropriately so. But for example, as well, if let's say there was a careless management, leaving money around or not taking care of conflict of interest, and there is a staff member who takes money out of the till, who is impacted? There's criminal liability as far as the person who stole is concerned. Would it impact the charity? It would as well. So are these risks that can be managed? Yes, if you know that that's possible, then board or management ought to have in place robust measures to make sure that these things, hey, there's a possibility that this is here and that's the other possibility. And in order to know how, please, your map is in the Charities Transparency Framework. So perhaps that's the way to go.
Thanks, Peggy. I think what I gather from what you're saying is prevention is better than cure. It's better to avoid this situation than trying to, resolve the situation when you're in the middle of it. And a very useful cheat sheet or handy guideline, as you said, is the Charity Governance Framework. And there's different areas, as you said, which could be very helpful to put in place to try and reduce or manage these risks. We've received an interesting question from the audience, and perhaps I'll ask Aurill to address it. If we provide medical care for the beneficiary, will it amount to admission of liability?
No, I don't see that it would. By admission of liability, I'm actually referring, perhaps there is a little bit of a legalese about this. In an admission of liability in the legal parlance would be one where effectively a party is saying that I accept that I am responsible for the event, right? So if I let's say in this scenario that we're looking at, somebody is injured, has fallen down, and basically what you do is you take care of the person, and even if you sort of like brought the person to the clinic and paid for that first doctor's visit, I don't see how that can be construed as you admitting that you are liable. It's got to be unequivocal. It's got to be clear that you are saying, I am liable. You could be doing this for a lot of reasons. You're kind. You just want to do the responsible and right thing of taking care of someone who's been injured. So I don't see that it would pass all the, it doesn't check all the boxes of a legal admission of liability.
Thanks, Aurill. And perhaps to add on, I mean, if you have activity and you have your first aid kit on hand, you wouldn't just ignore the injured person because you're afraid of liability. In fact, it might make things worse. Who knows, if you don't try to, as you said, arrange for medical assistance. Yeah. So our slight twist on the scenario is a volunteer pushes a wheelchair and the beneficiary falls off and gets injured. Angeline, do you have any practical pointers on how charities could organize activities to reduce litigation risk?
Yes, definitely. Before we go on any outing, we would always make sure that our staff go and do a recce first. When we go to that venue, we have to make sure that the roads or there are enough ramps, it's not full of potholes, safety measures most important for our patients. And then before we actually arrange for the outing, that we have to make sure that we get all the waivers signed by the beneficiaries, in this case our patients, before we go on the outing. And on top of that, we have to make sure that our volunteers are all trained on how to use the wheelchairs that we are going to be putting our patients on. And for us, we always have a minimum of 2 volunteers per patient, so that if one could push and one could look after, and just keep a lookout for each other. So when the volunteers are well trained in using the wheelchair, then hopefully it minimizes the risk of any falls. So those are all very important practical things that we will do before any outing.
Thanks, Angeline. I think a member of the audience did ask that I think when it comes to negligence or deliberate acts towards, I think, personal injury or death, I think the law may not allow you to exclude liability for that when it comes to personal injury or death. Let's move to the next scenario. So Apple Charity engages a caterer to provide food. The volunteers and beneficiaries come down with food poisoning. So this is a tricky situation. So far we've dealt with, a beneficiary injuring himself, a volunteer causing injury, and now we have a third party causing the food poisoning. So does Apple Charity face any litigation risk for this?
Yes, the answer is yes. Even though Apple Charity did not itself prepare the food, it is the event organizer. It did arrange for the food to be provided. And it, as well as the caterer, can be liable if, as a result of badly prepared food, people who consume it fall ill. But the basis of liability for Apple Charity and that of the caterer would be different. In the case of Apple Charity, its liability, it's not a strict one, i.e. it doesn't mean that just because a third-party contractor that you have contracted with, provided bad food, that you are automatically liable. The question is, what was your duty as the the party that contracted the caterer? What steps did you take, right? So the law will look at whether Apple Charity itself took reasonable care in its selection of the caterer. And you know, if in this case, Apple Charity went with a licensed caterer, not some fly-by-night operation, if Apple Charity followed the storage instructions of the food, because now food will come with storage instructions, right? How long you can keep it for, where do you store it, and if Apple Charity handled the food in the way that the instructions were given, if Apple Charity did everything that was reasonable and expected of it, then I think Apple Charity should be able to escape liability. Now, the other point that I think is worth noting is that if in this case, Apple Charity is sued, but the caterer is not, then as a matter of law, Apple Charity can, in the legal proceedings, bring in the caterer as a third party in the litigation and ask for indemnification. Now, it is in that scenario that it is very important then to look at whether in the contract between Apple Charity and the caterer, there was any limitation clauses or exclusion clauses, right? Because if there are, then Apple Charity may find that it is without recourse against the caterer.
Thanks, all. Angeline, I guess based on your practical experience, having dealt with, I suppose, service providers, do you have any pointers on how you try to reduce service provider risk?
Yes, normally what we would do is to, like Aurill mentioned, to just make sure that the food provider is trustworthy, is licensed. Better if you have used them before and they've been proven to be good. Of course, we have to make sure that whatever time we have to consume the food by, which is what Aurill mentioned as well, storage instructions, to make sure that we consume the food before the time is up. Sometimes the other problem is that we don't really have a choice in choosing the caterer. It could be sponsored by a donor or the volunteer themselves, and if that's the case, then we will still have to make sure that the caterer or the food provider is reputable, and we would at least give some feedback to the volunteer or sponsor if we do not think so.
Thanks, Angeline. Peggy, in this situation, Apple Charity paid the caterer to provide the food. But I think one interesting point that perhaps Angeline raised is what happens if the food is donated. Then it will be a very difficult conversation to have with a donor. So Peggy, do you have any tips on how to have such conversations with donors?
Yes, we often find in the charities that I serve, in some of them, there are sometimes mountains of bihun or canned food, sometimes food that's already cooked, and it's just left there. Sometimes arrangements are made, but in the non-perishable foods, you actually find sometimes sacks of rice, sometimes, or as I said, bihun. And it, of course, behoves the charity to first look at expiry dates. But again, that is managing that risk down to its very minute level. But having that conversation with that donor, in having that conversation, I think the question that has to be asked by charity, that charity should think about first is, to whom does it owe its duty? So this ties back with its mission. Because the fact that the charity is a charity does not mean that it should take all and sundry. And it matters not also that the donor is a long-standing donor or a one-off donor. Because whether long-standing or one-off, to whom does the charity owe its obligation to? Does it tell the children that it is looking after? Hey, it's going to be bihun, fried bihun for the whole week this week because we've got lots of that. How do they manage that? So those conversations, if it has to be had after the charity asks itself that question, to whom does it owe that duty and what is its mission? I think they will then be able to arm themselves with the right things to say to that donor, or not just to a donor who has already donated food or that may be too close to expiry, may not be good, or to potential donors who want to provide food. the charity ought to be brave enough and not just shy away thinking, hey, but it's a donor, we better not say anything to displease them. But it should be put up front and center that because we care for our beneficiaries, because we also feed our volunteers, if you are giving us this, may we ask this, and set it out clearly. Then everything is set out in the open, no feathers are ruffled. And in fact, I would also go further to think and say that your donors would appreciate that the charity is taking these steps front and center to make these things known, because this shows that the charity is thinking about its beneficiaries and its volunteers as well in its donor management.
Thanks, Peggy. I think that's a very useful point to raise. That at the end of the day, even though you have a regular donor who's helping to contribute at the forefront, you need to keep your interests of beneficiaries at heart. And as you said, perhaps, as you said, to ease or to head off this situation, it's better to set out certain framework or expectations so that you don't run into this situation where you're dealing with expired food, etc. All right, so let's move to our next scenario. So our next scenario, Mary is a beneficiary of Apple Charity. Apple Charity has observed that Mary is often forgetful and has even once lost her way when participating in a charity outing. Mary wants to give money to Apple Charity and to an Apple Charity volunteer under her will. Oh, this seems like good news for the charity, but is there any key litigation risk to consider?
Well, I mean, in this scenario, obviously, Mary's mental capacity is something that sort of stands out, right? In this case scenario. If Mary is an elderly, then there is also a question of her being possibly vulnerable and susceptible to undue influence. Now, if you want to talk about strict legal risk, right? The strict legal risk here is that Mary's gift, if she does put all of this in her will, may eventually be contested by her estate. And that is the legal risk. But I mean, if you look at it again, practically to a charity, you don't exist to receive gifts from beneficiaries, right? That's not how you raise funds. If it comes and it's a blessing and you take it with gratitude, but if it does not, it's not something you fight for. So which is why in this scenario, I don't really see it as a legal risk, because I would imagine that if at the end of the day, it went into the will and if it was contested by the estate, most charities will simply say, we'll let the executor or whoever is carrying out the wishes of the testator fight it out with the beneficiaries who have issue with the will, and the charity falls out of the picture. The risk I see is not a legal one. I think it's more a reputational one, because what can then happen in such a piece of litigation is that there will be evidence that has to be led as to the circumstances under which Mary drew up this will. And in such an inquiry, the conduct of Apple Charities volunteers, and in this case, if one of the volunteers herself or himself gets a gift, then the conduct of the charity and its volunteers will come under scrutiny. And it will then get very uncomfortable, and reputationally, I think there could be a lot of damage. So I would say that in a scenario like this, that the best thing for the volunteers and the charity to do is to say to Mary, you should really get independent legal advice to help you with this. Neither the officers of the charity nor any of the volunteers should be witnesses to Mary's will. They should not have a situation where the will is signed at the charity's premises, for instance. And in fact, I would go so far as to say that I would avoid furnishing any information to Mary for the purposes of doing up her will, because at the end of the day, if she's got a lawyer, the lawyer will know what information to put in, right? And the lawyer will know what what needs to be done to carry out her wishes.
Thanks, Aurill. At this juncture, just a gentle reminder to the audience that if you have any questions, please enter them in the Q&A button. So Peggy, is there anything else that a charity should note for legacy giving?
Well, at this point, I'd like to remind charities, you know, the saying that goes that if anything sounds too good to be true, it might just be too good to be true. Because here, especially even before the pandemic, but especially with the pandemic, there are lots of scams that are on the rise. And charities are actually susceptible to them because charities are run by people with good hearts. And persons with good hearts, in their hard work trying to live out their mission and doing the good work that they do, if they, for example, receive a call from someone saying, you know, I represent this particular estate, and this estate has named your charity, as a beneficiary. I need to have administrative costs because I'm coming from this place or that place. And when the charity hears it, on the face of it, wow, what a lucky stroke. But the charity would then need to think deeper. Is there money laundering involved? Is there terrorism involved? Because all these are larger issues behind the scenes that may not be apparent. Or for that matter, the person who calls up the charity, is it the right person that person claims to be? So it's not just about legacy giving, which is very good. And increasingly, the climate is that there is planned legacy giving for charities, and charities look at it as a very good way of raising funds. But as Aurill has very, very rightly pointed out, you know, there are these pointers that you must look at, make sure that it is completely objective, that the charity cannot be implicated in any way of unduly influencing the testator or the gift giver. So when you bear these things in mind, the charity needs to know and be aware that yes, there may be monies coming, it may sound good, but please be aware and please check. And this is where it is important that the leadership of the charity sets the correct tone. Because do we go on the basis of extreme cynicism to say whatever that comes about, hey, it may not be good, so let's not. Or do we go on the basis of the other end of extreme trust, everything is rainbows and unicorns? I would say there has to be a balance, and the word for it is caution. So for whatever that is being offered to you, accept it with thanks, but first view it with caution, and then go through the risk management that Aurill has so nicely brought us through to see whether or not it should apply to your charity. Okay.
Thanks, Peggy. Angeline, do you have anything to add about this situation?
Yes. So HCA has been quite fortunate in that we've been the beneficiary of quite a few legacy giving, and mostly from the families or the patients who have passed on. So we had actually encountered a case, I think it was about 3 years ago, where a beneficiary who had passed on left some money for us, but this was contested by the family. And then we were written a note by the lawyer to say that there's a contest going on for this legacy giving by our benefit patient. So what we did was we treated it at arm's length. We told the lawyer, just do what you need to do. You know, if the money comes, that's great. But if it doesn't come, that's fine too. So we didn't involve ourselves at all in, you know, the legal proceedings, and we just let things happen. And in that case, nothing happened, and the money didn't come to us. But I think that was a very safe thing to do.
Thanks, Angeline. I think as Peggy... Sure.
If I may just add on. Charities do their charitable good works, but charities are not professionals, and that's why they have external professionals to help them. So I would also remind charities, in preparation for possible legacies that will benefit them, that charities should have themselves ready internally so that they can have internal processes if and when there should be a legacy naming the charity. Would the charity be prepared? Do they have the resources to go to in order to help them to verify, to identify the risks and to manage that risk? And if they don't, then as Chairman has pointed out, Charities unit has got, in a Charities portal, there are the resources that are set up there, external professional resources that will help. For example, the Law Society Pro Bono Services will offer charities the legal assistance that it needs. If there are templates that are needed, it is also there. So the charities should prepare itself for these possible gifts or legacies that are coming, and not just meet it on a one-off basis, on a one-off case-by-case basis. So it is essential that they be prepared for it and rely and use the resources that are there, and also the funding that is provided. Thanks.
Thanks, Peggy. You mentioned about being careful. I mean, if it's too good to be true, please take a second look at it. So we do have a question from the audience about overseas donors, which is a little bit more difficult to check up on compared to a local donor. So are there any particular risk areas that a charity needs to be mindful of when they receive overseas donations?
Yes, I think a charity also first needs to know that under the law in Singapore, if funds are raised, and I'm using the word funds. I know your question is about
monies.
Donor. Yeah.
Yes.
And I don't know whether the monies are raised through a legacy or not. But funds that are raised overseas are subject to legislation, and the legislation is strict. So if there is an overseas donor that says, you know, I'm going to give you money, then the charity must be aware. Can it be construed as if the charity has raised those funds overseas? And then it must ensure that it complies with legislation so that it does not fall afoul of the law. And this will actually have sanctions. It is not just the court, it is actually the law.
I see. Thanks, Peggy. Another audience member asked if a beneficiary of the charity asks the charity to be the executor of his or her will. Any thoughts on that? Is it a good idea, bad idea? Maybe that's too involved, or maybe there's a service. Any thoughts?
I'm going to stick my head out on this one, and instinctively I would say it's a very bad idea. I'm not even sure if the charity is within the objects and the purpose of the charity to do something like that. It could be ultra-virus. But ultimately, I think it would be a very risky thing to do, particularly if the charity is going to end up getting some kind of a gift or a bequest.
Thanks,
I think that the charity must also be aware that in the first place, it must know whether or not it has the capacity to be as an organization. That's one. Two, it must know that the executorship position comes with duties and liabilities. And as Aurill pointed out, is that in keeping with your mission? Even if it will render you monies, or if it will get you some monies at the end of the day, but if it has an impact in the way that things are carried out, and as we said earlier at the start of this, all risks can never be eliminated. It can be managed, but it will never be eliminated. So you'll never know when something goes wrong. Is it worth the while, especially if the charity is one of the named beneficiaries? No, I would say no.
All right, thank you, Peggy, and thank you all. I think very good points. It may not even be the charity's capacity to even be an executor. And there's so many complications involved with that, and that's not the main objective of a charity. Let's move on to the Q&A segment. I would like to invite back Dr. Ee to the panel to take questions from the audience. And to the audience, if you have any questions, please submit them through the Q&A button. Given the large number of you, we will be taking a look at it through the Q&A button. So we have received...
Serene, sorry, can I just interject? And
Sure.
I just wanted to make a point of clarification before we launch into Q&A. And it arises from one of the points that was discussed earlier about, I think, exclusion clauses, right?
Yes.
And the question of whether negligence can be excluded. I think you're correct. Under the UCTA, one cannot use a contractual term to exclude liability for negligence resulting in personal injury or death. But for other types of liability, yes, you can, provided you spell out, clearly enough, right, that liability arising from negligence act is excluded. So what you cannot do is you cannot rely, even in the clearest of clauses, which refers to negligence, you cannot use it to exclude liability for personal injury or death.
Thanks, Aurill. Thanks for the clarification. And I think it's such a good reminder to the charities that your disclaimer or release forms is not going to be the silver bullet. You still do have to take care, especially when it comes to personal injury or death.
Serene?
Yes.
Sorry, I have one point and one question for our learned ladies.
Sure.
The one point is on legacy. Be very careful if someone wants to leave you a property in joint names. So one of the party, owner of the property, is very happy to leave it to you. And I actually encountered this. The wife wanted to leave the property to a church. Then I thought about it. Quite obviously, based on the condition, she will go before the husband. And what if the husband decides in his will to leave it to 3 children? Well, the charity is going to be stuck with the property and probably get embroiled into a lot of complications. So be very careful over legacy gifts. But the question I have for the ladies arises from the third scenario that was given, and it's not uncommon. I've encountered before. After an event, past the 2 hours, there's a lot of food left behind. And we have a habit of telling all the staff, oh, tapao, bring some home. And what happens if actually resulted in volunteers and people who actually take some of the food home and gets food poisoning? Who's responsible?
In my view, the volunteers who agree to the invitation to tapao home know that the food has gone past its service date, its service time slot. So they should therefore know that if they take it back and they get diarrhea from that, then charity or the person who's told them, please, there's so much food here, tapao, ought not to be liable. But Aurill will be able to tell you that with the right documents in place, with the right exclusions in place, ought not to be liable. But my point is, if it is stated clearly, then it should be okay.
Yeah, I think the caterer will be exonerated. So then my only question, so I don't think anybody can go after the caterer, right? If the food is consumed after the requisite number of hours. Then the question is whether the volunteers can say to the charities that, hey, you're the ones who asked me to bring back the food and not waste it, and now I'm coming after you. That one's a bit trickier. So it might be worth, before we invite our staff and volunteers to tapao back, that we say at own risk.
Yeah. Sorry, it's just I encounter this so often, and sometimes I'm very hesitant. But thank God, so far, no food poisoning has arisen out of it. Yeah.
No worries. All right, so I think we have quite a number of questions from the audience. And I think one hot question is COVID-19, right? So I think charities do have to continue operations. They will comply with the measures. Unfortunately, there always is some risk. So if a beneficiary does catch COVID-19 from participating in activity, is there any litigation risk for the charity?
Just going on first principles, I mean, I really don't see this as being different from any other scenario, whether it's going to work or going to the mall, right? We all are clear about what the safe management measures are. And I think if we comply with them, And it's not as if you complied with them and you're fully vaccinated, you would not catch COVID. So how do you even show that the charities, by organizing an event, had somehow caused or led to a situation where someone catches the virus, right? So I really don't see this as being different from any other ailments or sickness or flu, for that matter, right? In any events that you organize. I think causation would be a big problem for anyone to establish and to pin liability on the organization.
Thanks, Aurill. Does anyone else have anything to add to that?
I suppose unless the charity has been negligent in enforcing the safety rules, whereby, especially in the current situation where you're supposed to check that certain people have had both vaccines, and you have a mix of those who haven't been vaccinated with those that have been vaccinated by less than the 14 days. So there are certain procedures that has been laid out each step. And if the charities have complied with all of it, as Aurill say, I don't see how the charity can be taken to task. But if the charity had been negligent and didn't ensure everyone wore their masks and kept the safe distance, then there's a question mark there.
Thanks, Dr. Ee.
We also have, quite a lot of advisories that we follow from MOH or AIC. And I think if we conform to that, we should not be liable in that sense as well.
Yeah.
Thanks, Angeline. Thanks, everyone. I think the message is pretty clear that it is a risk, but that should not stop the good work. And do keep an eye out for all the government measures and advisories and comply with them. So we have a very practical question from an audience member. Volunteer turnover is very high. People come, people go. Very often a volunteer may just drop in for 1 or 2 hours. So what they do is they just paste the disclaimer or the notices on the doors or on the walls, but they don't get the volunteers to sign anything. Is that sufficient? Or any thoughts from a legal perspective?
Okay, so I think at the end of the day, when we talk about exclusion clauses or limitation clauses, there are a few sort of considerations. One is whether first of all, whether the clause is clear enough, right? Then you have to consider whether the clause is unfair or reasonable. Now, assuming that you get past both of those, then you have to ask yourself whether the term has been properly incorporated into the arrangements. And I don't know if those of you who are lawyers here, whether you remember your contract law where, the car park scenarios, you drive into a car park, right?
Yes.
There's so many of those cases, right? You drive into a car park and then before you enter the parking lot, there's this huge sign that says management will not be responsible for any damage to your car, etc., etc. Then you go in. And then I think case law has established that by going in, you have indicated by your conduct that you accept the terms before you use the car park, right? So the third point, as I was coming to, is whether the term has been properly incorporated into your contract or your terms of engagement with the party. So using that model, if you like, to analyze the situation that you have just put up, Serene, I would think that if a volunteer walks into an organization and prior to undertaking any activities, there's a large and prominent enough sign to say that, by agreeing to volunteer, you are agreeing to A, B, C, D, then, and it's clear enough terms, whatever it is that you want to convey, I think you can get past the incorporation hurdle. So you've incorporated those terms into your engagement with the volunteer. Then the next thing is whether the terms are clear enough, whether it is reasonable, right? Because if it's unreasonable, again, you're going to have problems with enforcing it.
Thanks, Aurill. Perhaps I'll ask Angeline from a operational or practical perspective, how do you go around getting your volunteers to agree to the disclaimers or such? Do you have a registration form or how do you go about it?
Yes, we do have a form, and no matter how important we know the volunteers are to us, we still think that following the process is even more important. So everyone needs to be at least orientated, how to handle, how to manage our clients, rather than just let them walk in and, read something on the wall. So they have to sign off all the disclaimers and all the other forms that are necessary before we allow them to volunteer. It might be more difficult then for us to gather more volunteers, but we think that's worth the risk.
Serene, this is the reason why Angeline's organization, the HCA, has won an award, because they have taken to heart and taken on very seriously the pointers in the Charity Transparency Framework, one of which is for volunteer management. So they've made that decision that it may be tedious, it may be more tedious, it may be difficult, and it may necessitate engaging that volunteer to say, I hope you understand, we need this done, and then have it all properly signed and done. Now, apart from that, I think the charity should also be looking at the activity itself. Yes, this volunteer may come in fleetingly, once, twice, for a few hours, but what is the activity that this volunteer is engaged in? Is this volunteer going to be, for example, placed alone with children, unsupervised? Is this volunteer going to be in a position where there's food preparation and there's no supervision? So I think the charity needs to see this in perspective as well, even as they are managing that volunteer.
Thanks, Peggy. One audience member, I think, was hearing about the legacy giving situation. So they mentioned that, of course, there's no details, but they mentioned that sometimes they encounter beneficiaries which do not have any dependents, and they're it. There's no one else. So sometimes for compassionate reasons, they decide to help be the executor. So they did share that it is possible, but there are a lot of extra steps involved. I mean, not sure if anyone's add to that, but I suppose that's a very practical on the ground situation, perhaps for that particular charity, that they're dealing with beneficiaries that has no one else to step in and be the executor.
Yes, I've encountered a situation like that, where the testator, the one who wrote the will, has no family, and the only friend that he had, or that he has at the time, are the persons in church who help him and give him money. But the risks are there, and he may say that he doesn't know, that he has no one, but the persons with whom he's interacting with would not know any better. They're not private detectives, and there's no way they will have visibility into his personal life. So what has to happen is to be very careful when he says, I want to draw up a will. That's his specific instruction number one. I want to draw up a will. I want to give it all away to Charity A. So on those instructions, one has to be mindful, I think, to ensure that, as Aurill said, mental capacity, number one, to make sure that it is absolutely clear and above board that the named charity that an allegation cannot be made that the named charity has exerted any undue influence. Number three, make sure that there are also witnesses. If that person is engaging in charities activities, there would be videos, for example, of activities which would show this person being lucid, being able to speak clearly, participating fully in activities. All these helps in addressing a situation should the untoward arise after his passing. These are just some points.
I think, Serene, I would draw a distinction between those cases where the charity itself is also a beneficiary, against those where the charity is not going to get anything under the will. So I still think that it's very dangerous for the charity to be the executor, because as an organization, if you've got no capacity, you've got no capacity, right? But if we're talking about an individual, either a volunteer or a staff stepping out and saying, in my own personal capacity, I know so and so, and I'm prepared to be the executor. Okay, I mean, very exceptionally, I can understand that, and I can see that there may be situations where that needs to be done. But then again, with mitigation of risk in view, you would still say, please, to the person, please go and see a pro bono lawyer to get that will drawn, because I shouldn't draw up the will for you. No one in the charitable organization should draw up that will for you. Go see an independent lawyer, get that independent advice. Now, if then the person says, okay, you, Mr. A or Mr. B, be my executor, fine. Then A or B must, and his related persons must not be beneficiaries under the will, right? And I would even say that if the charity is then a beneficiary under the will, already it's going to raise some sector of concerns, because if you're a staff or an officer of that charity and the charity benefits under the will, I think there could potentially be some concerns. So again, these are the careful grounds, I think, to sort of navigate. You need a lot of wisdom to arrive at the correct decision. But independent legal advice, I would say, must do. And the person who's executor should be very, very careful about being the beneficiary under the will in such circumstances.
Thanks. Interestingly, an audience member has mentioned that their charity actually helps deal with this actually. So that's interesting. There's a charity set up to help to deal with such a situation. I think for persons who have difficulties, arranging for their wills, etc. So perhaps that is one option for charities to look out for. So there's a charity out there who does provide such services. I mean, so that's good. So we know that this is also being addressed as well. One question we have, which is quite interesting, is donations in kind. So for donations in kind, for this particular audience member, they do want to make sure there's a certain quality standard. It's something that can be used. And they were wondering, instead of accepting it as a donation, should they just put in place a contract of sale and pay a minimum sum to the donor so that there's some sort of contract that they can enforce if they find that the donation in kind is not up to standard or there's defects, etc. Any thoughts on this? Perhaps I'll ask Aurill first. Whether she thinks there's a difference between just accepting a donation in kind versus putting in place a contract or service.
I don't think the law looks very kindly on arrangements that are put there for form rather than substance. So that's my first gut instinct. So if anybody came to me and said, actually, this is a donation, but we want to dress it up as a sale contract, and this is $1 consideration, I'll be like, okay, and why would you want to do it? Oh, so that I can make the person liable. So instinctively, I'm not sure that is going to cure all the ills. But let's go back to basics again. What's the purpose of putting it as a contract? So that you have some legal basis for making the other person liable, presumably, right? And if that's the case, I do wonder whether you would be looking at it under the common law as well, which is that if you knowingly give something, well, I guess the difficulty would be that if it's a donation and it's for free, it's up to the person who's receiving it whether you want it, and if you do, you take it at your own risk. So I think, to be honest, the way that I would approach this is, as a charitable organization, make an assessment. Do you want it? Don't want it? Why? This is my personal view, right? Why go through the trouble and the hoops of dressing it up as something which it is not, just to pin liability? If you don't think that it's good enough, just politely say, no, thank you, we won't take it.
Just to add to that, Serene, the Inland Revenue Authority of Singapore makes a distinction between donations and sponsorships. So in an attempt to use that word, dress up, the transaction, the charity has to be careful and has to be mindful whether or not there's an impact as far as IRAS is concerned as well. So I totally agree with Aurill. If they are in doubt, there is no need to just wholesale accept it. Please consult the professionals, and there are accountants that are there, who will be able to advise. And these are accountants, these are services that have tied up, professional services that have tied up with the charities unit. So the charities that are listening, I hope, will want to be able to use them and can use them. Thanks, Peggy.
I would add that if a donor wants to donate something to you, then, why would they, have to sign anything else with you? You either accept or you don't accept. For us, we receive quite a lot of bids, hospital bids. So we do have to accept, if we accept, to check, do maintenance to make sure it is safe for the next person who's going to borrow it. But otherwise, if we think that it's not good and we've already taken it, then we just discard it after that, dispose of it. I suppose sometimes we are talking about donations of, say, paintings, and then we try to sell it thinking that it is a Van Gogh or something like that. And we have to do our own assessment before we price it, right? If it is not real, or if it is just a copy or whatever, then we price it accordingly and we sell it. Otherwise, if we're not sure, then don't put it up for sale, or don't put it up at such a high price. And whoever is buying it has to make that own decision. So I think that's how we would handle it.
Thanks, Angeline. That's so useful. Very, very operational and very practical advice. Now, there's an increase in use of crowdfunding platforms. So could the panel share their thoughts on how a charity could approach such platforms? I think the thinking is, nowadays there's so much crowdfunding. It could be either through a formal way, through giving.sg, or could either be informally, someone on their Instagram or Facebook says, hey, everybody, I would like to raise money for a certain charity. Is there any thoughts towards how a charity should approach such crowdfunding activities?
There is in place online fundraising. There's a code for online fundraising. So this would fall squarely within that. So the charity ought to, again, at the risk of repeating myself, because there is a wealth of information on the charity's website, go there. Because it is in a code, the language is very simply set out, and it is easy to follow and easy to abide by. So to ensure that you do not fall afoul of these regulations in the code, go there and follow. It is there. But crowdfunding, exactly that.
Okay, so great news for the audience member. It's addressed. So go to the charity unit's website, which has a topic, I guess, dealing on that.
I think, Serene, I'd just like to add on. I suspect the one who asked the question is trying to decide the form of raising funds. So whether you call it crowdfunding with your digital form or the traditional fundraising, it is storytelling. And really, if you look at the success of crowdfunding, it is a story that is being told that touches people's heart and make them respond and donate. So in traditional fundraising, why in many cases it's not terribly successful is the charity don't tell a compelling story enough to make people reach for their wallets. So actually it's just a different form, but really the key to raising funds is how compelling your story, can people connect with you and therefore wants to support your cause.
Thanks, Dr. Yee. All right, the next question is, I think dealing with, so far for Singapore charities, you do have beneficiaries who are based in Singapore. So this audience member is dealing with a beneficiary who has moved back overseas. So are there any risks that they need to be mindful of if they were to continue to donate money or transfer money to a beneficiary who is now perhaps moved back home overseas? Perhaps I'll ask Peggy if she has any thoughts on this.
This is to support a beneficiary that has moved overseas, right?
Correct. So originally was in Singapore, now has moved yes. Overseas.
There are also regulations for a charity to move its funds out of the country. There is only a certain percentage within which you can move your funds out. Because, as I said earlier, there are regulations regulating fundraising in Singapore and outside of Singapore. So flowing from that, if you raise funds in Singapore, it is meant for usage in Singapore by the charity. If you then move those funds overseas, there must be that it must comply with the regulations set out. And so long as it does not exceed the percentage that's set out, then I say this very generally, then it ought to be okay, but it really has to be addressed on a case-by-case basis. So the mere fact that we supported this beneficiary when this beneficiary was here, he is now no longer residing in Singapore but has moved, that in itself is not going to be your okay, carry on. They will still have to ensure that they do not fall foul of the established regulations in Singapore.
Thanks, Peggy. Another question we received, perhaps this is more towards Dr. Ee and Peggy. They were wondering whether there's any thinking around group insurance for charities. Rather than an individual charity going to an insurer one by one, is there any thinking about perhaps as a group, would there be economies of scale, especially if there's similar insurances that charities would like to purchase for activities? Dr. Ee and Peggy, any thoughts on that?
Well, I'm not aware of there being any attempt, but let me share an experience with you about group insurance. And very often in certain sectors, like in the accounting sector, and they go by territory. So you have Asia Pacific region, and all the firms under the particular brand will come under the group insurance. And when one incident happens in one country, it affects the premium of all the countries within that group. That's how insurance companies work. And the question is, are we ready? Is everyone up to par that you want to share the risk? And you have a group of charities, like say 20, 30 charities coming together as a group insurance, and not all of them are at the same level of governance and of risk management. And you want to share the higher premiums because incidences happening from a member of the group that has been lacking. So I think that is a very big question mark. Whereas if you just deal with your own organization, ensure you have very good governance, you have no incidents, I think it's much easier for that individual charity to manage their premium. But as a concept, at some stage when enough charities or if 4 or 5 charities who are comfortable with each other's level of governance wants to come together and discuss with insurance company and say, can you consider our needs on a group basis? I think that's possible, but not as a sector itself.
Thank you, Dr. Ee.
I echo that. At the present moment, we don't have that in place yet. It's an excellent idea because it really banks on economies of scale. But right now, because every charity has got such differing size, constitution, and the range of activities, and therefore the risks that are involved so diverse, on a practical scale, it is not possible yet. But perhaps, taking the suggestion, it is something that we really can consider just to maximize the economies of scale. I thank that person for that question.
Thank you, Peggy, and thank you, Dr. Ee. Interesting idea to consider, and I think as Dr. Ee highlighted, there's good and bad with it. One thing is, if one particular charity claims a lot, it means the risk is shared among everyone else as a whole. So the other question that we've received from the audience deals with photos and videos taken during events. So I think that person perhaps thinking of Dr. Ee's comment that, you really have to power through with perhaps a beneficiary's testimony, to show the good work that the charity is doing. So for photos and videos taken during events, can it be used in the charity's social media? And beyond just reporting the event, perhaps in the future, they would love to keep showing the photo in perhaps fundraising or perhaps in their own videos, etc. So I think the question is there any risk in taking photos that we've taken at a particular event and be using it for other purposes for the charity?
Maybe I can start.
Sure.
I think for us, it is very important to get patients' consent for photo taking. So if they don't give consent, we usually identify them with a tag or a different tag that people will know. If we accidentally take their photos, then we will delete it before we so that it doesn't get shared accidentally. Otherwise, for the rest who agree to photo taking, then we'll be okay to share it on social media or any other platform.
I think on a bigger issue is one of ethical standards. Especially in some cases, you may take a picture of one of your beneficiary and you use that for fundraising. What are the impact of this beneficiary whose face then appears in social media? Do you want the whole population to know, poor thing, this child has this condition and things like that? I think that is an ethical issue and is a very big struggle. But whatever the case is, if you're dealing with a more adult beneficiary, get the consent of the individual itself. The individual may feel a great sense of gratitude of being helped and would like to offer itself to help the charity to raise more funds. I think that's fine. But it is really a very difficult balancing point. You have to bear in mind, are you being ethical? Are you making use of the beneficiary without the beneficiary really appreciating that his or her face and name is being broadcast right across? And once it goes on social media, it doesn't disappear forever. It remains there. So 20 years later, somebody search it and say, oh, when you were a kid, I saw you in this condition and that condition. So be careful.
Serene,
just to add, sorry, after you, Peggy.
Yeah, Serene, just to add on to what Chairman has said, quite apart from consent and release being obtained from the beneficiary, quite apart from that, I think we need to look at the dignity of the beneficiary, because there are ways to tell the stories that Dr. Ee has spoken about. There are ways, and the very traditional, typical way is to take a poor thing photo and say, there, poor thing, can you give? I'm putting it very simplistically. But when you do that, one, is it a very jaded way of doing things? And two, more importantly, are you as the charity respecting the dignity of that beneficiary? Because you must know that when you obtain that consent and release from the beneficiary, usually it is a beneficiary of the charity, right? And the charity would have said, hey, this is a donor, they're funding us for this, they're sponsoring this, we sign. And we'll tell that beneficiary as well, sign. And that beneficiary will sign. But how much of that is consent? And as you go down the line, how much of it impacts the dignity of this particular person? I'll give you an example. There is a charity that raises funds, this hospice that raises funds. And instead of showing its beneficiaries in their very frail, weakened condition, and therefore say, please give us the money, which is the message, they showed this beneficiary without his eyes, just a smile to show that, look, this is where your monies have gone. It has provided him with a smile. And that brings that message very nicely without impacting or lowering the dignity of that beneficiary. So I always use the example because I feel that the charities can move away from that traditional model of fundraising and begin to really look at and protect the dignity of the beneficiary. Thanks.
So Serene, I was just going to add, and I know that no action or enforcement action has ever been taken along these lines under the PDPA. But technically speaking, under the PDPA, organizations have a duty to protect personal data, right? That is in its possession, and it has a duty to what the law says, make reasonable security arrangements to prevent unauthorized access, disclosure, copying, or similar risk. And as to what constitutes personal data, it is data about an individual who can be identified from that data. If you take that definition as it is, a photograph is data about an individual who can be identified from the data. Now, I'm aware that a lot of the enforcement cases that we have seen have been about leakage of NRIC numbers, application forms and names and that sort of thing. So I'm not personally aware of any enforcement actions taken in relation to leakage of photographs. But coming to this question, I think this is good reason for charities to be very, very careful about use of video footages or photographs. And I like what Angeline said at the beginning, that you just ask for consent, and if people do not consent, you respect that, right? And you don't use the photographs.
Thanks, Aurill. An audience member had a follow-up question to, I suppose, events, which I suppose is quite popular nowadays to take photographs during events activities. So is it all right if you have a poster at the entrance, perhaps, or at the event itself, to say that, look, if you don't want your pictures taken, please let any of our staff know? So is it possible, or perhaps the person's thinking from a practical perspective, let's just put a poster there as opposed to making every individual sign a consent form? Any thoughts on that, Aurill?
No specific thoughts, but I will tell you for a fact that I have attended seminars. When I sign up for the seminar, I have to agree to photographs being used for promotional and publicity, purposes. And I'm just an attendee. So I think that these sorts of things can be done without too much difficulty, actually, if you feed it into your process early enough.
Thanks, Aurill. So this is an interesting question, but I felt it's something that needs to be mentioned. So this audience member said, understand perhaps there's PDPA concerns, and are charities obliged to give details of donors to ministries when asked? I mean, I think the answer is pretty obvious, but I think it's good to get that.
I think that's a very specific question for which I'm guessing that there will be a very specific answer somewhere, especially when you say ministries, right? Are you referring to MCCY or, some other ministries, but, and what powers are they exercising, because for instance, the police will always have rights under the CPC, right? And if, let's say, if MAS was investigating into into a money laundering issue, they will have authority to ask for information, whether you're a charity or whoever you are, right? So I think my rule of thumb is that when anybody is asked by the authorities for any information or documents, you are well within your rights to say, may I know under what statute or what powers you're exercising these powers, and the legitimate authorities would be more than happy to tell you, I'm exercising my powers under this act, under that provision, and then you can comfortably give the information.
Thanks, Aurill. And I think because we don't know the reason or basis for the audience asking this question, do be aware of scams as well. I think there's quite a number of scams. So it's some random person calling you on the phone, maybe you might need to double check. So you might need to be cautious about that as well.
Absolutely.
Yeah.
And for people who say that I am from the police or from whatever, that may not be the case. So you really want to see proper documentation, and sometimes you might want to check with the relevant authority whether there is really such a unit or person, right, asking for the information.
All right. So another, sorry, before I go on, does Dr. Ee or Peggy like to add on anything to that? No.
I think Aurill has dealt with the question. Just be very careful, and if it's from an authority and they can quote the relevant powers that they have, then you're obliged to. In any case, for IPC status, every year you submit a whole list to Inland Revenue for the tax receipts. So I can only guess that this question relates to donors who are not looking for a tax deduction. then that raises other issues.
All right. Thank you, Dr. Ee. So I think picking up on, I think one of the threads running through this discussion is the need for due diligence in sense of when you get high value donations, especially from overseas individuals or local individuals. So this audience member has a practical question. Is there a database that we can perform some sort of search to check if this person is legitimate or this person is someone whom we should not accept donations from?
Serene, in law, we have this thing called KYC, know your client. So here is about KYD, knowing your donor. But I think at the end of the day, it is about doing your due diligence. So remember what I said earlier, if something sounds like it's too good to be true, it may be too good to be true. There's no need to be completely cynical, but that caution must be exercised. So as far as I'm aware, there is no central database like ACRA that you can check this company's name and you know who the company directors are, how much their shared capital, the paid up capital is. There. As far as I'm aware, there is not. But in order to ensure, in order to deal with this potential donor, I think board and management, if it's very big, management ought to float it up to board as well in order to get board's input. And then that due diligence must be done. The checking can be done, because if it's, say this donor is from Haiti, Nigeria, so that should already start ringing some bells. Or let's say it's from, and I'm not going to name any other countries other than that, but some checks can be made. And remember, again and again, there are professionals that can assist the charity when they navigate this. So proceed with caution.
I think minimally you should Google and do an internet search about the companies. And if your firm is a member of an international network of firms, talking about the smaller audit firms, and if it's one of the big four, then of course they have offices elsewhere. You can always get the assistance to double check with the offices in the country to validate it. So there are ways around it, especially if you're talking about a huge donation from someone whom you don't know. But if it's someone that you know, that is a different flavor altogether. Then you need to document the purpose. Why is this person making the donation to you, and so forth.
Yeah, I'd like to give an example of we had a donor who walked in with a thick stack of $1,000 notes and offered to donate to us. Of course, when you look at the stack, it's very tempting, right? And it didn't help that, we had a neighbor who's also another charity. So if I were to decline the donor, he would just walk next door and perhaps give that thick stack to the neighbor, right? So, but, we had no choice. We asked the questions, the difficult questions, where did your money come from? But before we did that, we explained to the donor, we have to do our due diligence so that, we have to protect each other. And we asked the difficult questions. And then when we were satisfied with the answers, well, I mean, the donor could have not told us the truth, but as long as we asked and, we've recorded what he said, then we could accept the money more calmly and without worry.
Yeah, I was just going to add there that, in my view, I think due diligence is not just about checking against a register to see whether the person is blacklisted, right? Into due diligence goes very commonsensical approaches, like what Angeline just mentioned. You would be asking questions like, why do you want to give to us? What is it about this cause that appeals to you? Why are you giving so much money? Why to Singapore if it's an overseas donor? Why suddenly, right? A lot of these questions, and it's not just really about analyzing the answers that come back. It is also about observing the response of the person who's giving you the answer. And it's an assessment, it's a judgmental call on whether in that conversation and dialogue, you are picking up red flags that or alarm bells that are ringing that are saying, okay, there is something not quite right about the explanation that is given or about the reason that has been given. So it does take time, but it's not really about, doing. It is not always about running checks and, making sure that it's clear, because you can run those checks, they can be clear, but if the answers don't add up and it's a huge sum of money, I would still say that the due diligence test hasn't been passed.
Thanks all. And I think, and thank you so much, Angeline. I think it's so enlightening to hear very practical, real life examples and, to hear how it's being tackled. So unfortunately, our time is running short. So this brings our Q&A session to a close. We would like to take this opportunity to let you know of the Charity Transparency Award and the Charity Governance Awards. These awards are an initiative of the Charity Council to promote good transparency and governance in the charity sector by acknowledging the excellent work of charities while inspiring others to emulate the winner's best practices. If your charity is eligible, please submit one form by 31st October 2021. If you need help with the submission of the form, SMU student volunteers have kindly arranged for a consultation clinic. For more information on the eligibility criteria, the consultation clinic and awards, please visit the charity portal. The QR code and website link can be found on the screen. After this webinar ends, a feedback form will be shown in your browser for your completion. The link to the feedback form will also be sent to you in a follow-up email tomorrow. If your charity needs legal advice, please email us at assist@lawsocprobono.org.sg. On behalf of Law Society Pro Bono Services and Charity Council, we express our gratitude to our speakers for joining us today. We also thank all of you for attending today's webinar, and may you have a great week ahead.